This podcast episode reflects the opinions of the hosts and guests and not of Greenberg Traurig LLP. This episode is presented for informational purposes only, and it is not intended to be construed or used as general legal advice nor a solicitation of any type.
Welcome to GT Big Law Redefined podcast. We're here today for the inaugural miniseries episode, Changes in Delaware Law. I'm your host, Samuel Moultrie. I'm a shareholder, corporate litigation in our Delaware office. I'm joined by my two guests today, Sarah Martin, who's a shareholder in our Delaware office as well. She practices corporate and complex commercial litigation. And Justin Mann, another shareholder in our Delaware office who practices in corporate and commercial transactions. So we're here today to discuss new changes to sections 144 and 220 of the Delaware General Corporation Law. We're going to refer to it as the DGCL. And if you've been at all following Delaware law recently, then that in March of 2025, Delaware enacted changes to section 144 and section 220, colloquially known as through SB 21. And these changes were made in connection with decisions of directors, independent directors, disinterested stockholders regarding legal transactions with directors, officers, and controlling stockholders. And of course, amendments to section 220, which involves the stockholders' right to seek certain books and records from a company. So with this, as we kick it off, Justin, Sarah, I think it's best to talk about a little bit about the background, what the law was prior to the changes to section 144. Sarah, can you tell us a little bit about kind of where the law was before March of this year?
Sure. So historically, and following a case called Easy Corp and various cases that emerged from that, which did an extensive review of Delaware case law, those cases held that the entire fairness standard of review, which is the most onerous standard of review under Delaware law, which requires a fiduciary to prove both fair price and fair dealing in connection with the transaction, that entire fairness standard of review wouldn't apply just to what we traditionally thought of as controlling stockholder transactions, like a take-private transaction, but that would apply to any transaction that provided a controlling stockholder with a non-ratable benefit that wasn't shared pro rata with all stockholders. So post Easy Corp, we don't have a world where it's just controlling stockholder take private transactions, but things like contracts with controlling stockholders, financing by controlling stockholders that in some way gave controlling stockholders a unique benefit that are now subject to the entire fairness standard of review.
Yeah, and also we should mention a little bit about MFW and kind of what the context for that was. Justin, you want to talk a little bit about MFW and let our audience know what that case was, what it held, and maybe what started what we call the MFW creep, which led to these changes in 144?
Certainly. So as Sarah outlined, the application of entire fairness to controlling stockholder transactions was under a standard for a number of years. No one had ever won at trial on entire fairness. So having an entire fairness claim was essentially seen as a case winner or gave plaintiffs massive leverage.
And Justin, can you just tell us real quick, entire fairness, just explain it just a little bit in case some of our listeners don't have a great grasp of that yet?
Certainly. So entire fairness requires essentially, or usually the defendant to prove the fair price and fair dealing in connection with any transaction. So you're looking at methods that are reasonably acceptable in the financial community to prove that the price was totally fair to the minority stockholders, disinterested stockholders, and that the process employed in getting there was also entirely fair. So there you're looking for unconflicted fiduciaries who aren't sandbagging the process to enable a deal to come together and the terms get put together. Prior to MFW, there was a deal protection device that allowed a special committee of disinterested directors or an informed stockholder vote to shift the burden of proving entire fairness from defendant to plaintiff, which folks kind of saw at the end of the day as a little bit of weak tea. Following MFW, the courts announced essentially a new standard, which said that if you have a transaction conditioned on dual conditionality of both deal protection devices, that is approval of the disinterested special committee and a vote of the majority of the disinterested stockholders, you can get out of entire fairness review and you can go back to business judgment rule, which is where everybody wants to be. There's no liability for business judgment rule cases unless the court finds that you essentially engaged in waste or gross negligence, which is just extremely rare and only been found on a few occasions in Delaware law. The MFW standard required that the transaction be conditioned at the outset, which meant before economic bargaining, the approval of the Committee of Disinterested Independent Directors and approval by a majority of the disinterested stockholders voting on a fully informed and uncoerced basis.
Great. Thanks, Justin. And so we have Easy Corp, we have MFW, we have this framework, and it really was largely involving controller freeze-outs. And then the law started to progress a little bit. Sarah, you want to talk to us a little bit about what's been colloquially called the MFW creep, although that might be a little bit of a misnomer, and some of the more recent cases that are applying this law maybe in a little bit different context?
As we mentioned, historically, you thought that controlling stockholder transactions that were a controlling stockholder buying out the rest of the minority stockholders, and therefore what we call a take-private transaction, that those were what was subject to entire fairness review. But you then get this situation where now you have Easy Corp, which is saying, well, any non-ratable benefit that a controlling stockholder gets in a transaction is subject to entire fairness review. So now you have this sort of creep beyond historical context. You have cases involving potential equity compensation awards to controlling stockholders. That's Tornado v. Musk. You have issues where maybe there's a private placement that's done with a controlling stockholder where they're getting favorable terms or being able to invest on terms that other stockholders aren't being asked to participate on. And so you get this body of cases. You get Match Group, you get Martha Stewart, Omnimedia, where all of a sudden what we traditionally thought of as the sort of subset of cases that would be subject to entire fairness review have now been expanded. And with MFW, you can now put yourself back in the business judgment world by applying MFW to these types of transactions. But it's often impractical because, as Justin said, MFW requires having a fully empowered special committee, right? So that means financial advisors, legal advisors, those cost money. It also means having a stockholder vote. And if you're doing a stockholder vote where you're not otherwise statutorily required to, that gets really expensive. When you're doing a merger, you have to have a stockholder vote anyway. So it's not that big of a deal to say, okay, we're going to have a minority of unaffiliated stockholders also vote on this. But if you're just, say, doing a private placement stock offering, or you're having a compensation plan, or you're engaging in a debt financing with the controlling stockholder, you wouldn't normally have a stockholder vote on that. And so now all of a sudden, to put those back into business judgment review, you're having to go through the whole hurdles of an MFW process. And people are saying, well, gee, now we have these transactions that we didn't historically think were subject to entire fairness review that are now subject to entire fairness review. And to get out of it, we're going to have to go through this very onerous and expensive MFW process, which even then, at the end of the day, stockholders can still challenge the MFW process. They can say, you didn't have a special committee formed ab initio. They weren't there early enough before you had economic negotiations. The directors aren't really independent on the special committee. The stockholder vote isn't fully informed. So you have transactions that you're going through the MFW hurdle that you didn't think you'd have to do it. And the MFW hurdle is expensive and people still may not do it right. And then you're still subject to being back in this entire fairness standard of review. So that's where people started complaining about, we've got this expansion of entire fairness and it's becoming very expensive and fraught with risk in order to try to bring it back to the business judgment rule.
Yeah, and we had a lot of high-profile cases, most notably the Elon Musk case, which really kind of brought this issue to a forefront. And is it fair to say, to kind of summarize this, as the MFW entire fairness got broader, let's say, that it created a lot more like uncertainty of outcome, or made it a lot more difficult for companies to engage in these type of transactions, which may not necessarily be bad transactions or negative transactions for the company and stockholders? Is that a fair assessment, you think?
I think so. And there's also sort of uncertainty on the front end, whereas the deal maker, when you're advising a client, do you even need MFW? Where you're saying, well, I don't think you're a controlling stockholder because you own a minority number of shares, so therefore you're not what's traditionally considered to be a controlling stockholder. So you say to someone, I don't even think you need to do this MFW process because I don't think you're a controlling stockholder. And then the transaction becomes subject to challenge, and it turns out that the court thinks that it's reasonably conceivable that you are a controlling stockholder because your percentage of voting shares combined with influence in the boardroom plus some kind of managerial influence has made you a controlling controlling stockholders. It became more difficult as a deal maker to, number one, say, what are the contours of a controlling stockholder? Are you even going to be deemed to be one such that entire fairness is going to apply? To trying to do the MFW process correctly, which, yes, there's sort of broad contours of how we should do it, but there's still room for footfall within it. And then you've, got this frustration of, well, we thought we did everything right, and now we're still subject to challenge, and we just went through this entire very expensive process of having a special committee and a stockholder vote, and we're back in entire fairness land. So it really becomes an issue of stability and predictability of how, as we are advising companies and fiduciaries and clients on how to structure a deal and what kind of protections you should put in place, being able to, we can't give you a guarantee or best guess as to have you done it right and will this be immune from challenge.
Yeah. And Justin, do you want to talk a little bit about that and also maybe some of the issues that were going on with the books and records that led to the amendments to Section 220 as well?
Sure. So, I agree with everything Sarah just said. And at a high level, plaintiffs got very good and very focused on these controlling stockholder entire fairness claims. And there's statistics out there that showed even for companies and stockholders who employed an MFW process, the actual chances of success, even in employing one, were pretty low. Like it was worse than a 50-50 shot of it holding up through trial. Again, that people tried to take advantage of governance and deal protection devices in case law, spent a lot of time, a lot of extra money, and we're not seeing results. As Sam, as you alluded to, kind of hand in hand with this focus and success on defeating MFW processes and controlling the controller transactions, plaintiffs were also employing what's known as the 220 books and record demand process, which the court had for a number of years encouraged plaintiffs to use prior to filing any plenary litigation to determine whether or not there was any fiduciary claims. And hand in hand with controlling conflicted transactions, plaintiffs were taking advantage of Section 220 books and records demands to get access to company documents to investigate and determine whether or not there had been any wrongdoing going on. The courts had for a number of years encouraged plaintiffs to use this tool at their disposal prior to bringing suits to essentially look at corporate records. The use of this became widespread. Companies spent a lot of time and money reviewing and responding to these demands. And the case law also evolved in a way where if there was records or gaps in records that were missing from a corporate minute book or board resolutions or committee resolutions, the court was granting access to plaintiffs to direct or text and emails, which became a hugely burdensome process for companies and directors to collect and produce these documents. It led to, I think it's charitable to call it a cottage industry of claims and cases where you were essentially, your companies were getting a 220 demand on almost every transaction that was done, especially for public companies.
I can appreciate from our end, from the litigation side, the proliferation of 220 cases and the extent of documents that were being sought by plaintiffs significantly increased and became much more subject to contentious litigation over the years, which made it extremely difficult on the company sides to continue to fight against this going forward. So we have now this change in broadening of MFW. We have this proliferation of books and records litigation coming via Section 220. And this kind of led to, and I think it's fair to say, a number of larger high-profile corporations beginning to say, hey, what's going on? Is this the right way to go about this? Is this where we want the law to be? Should we continue to be in Delaware or should we be elsewhere? And we're not going to get into that big debate. I think it's been well discussed. But what we are going to talk about was really Delaware's response, and a swift response. In March of this year, Governor Matt Myers signed what, again, we call Senate Bill 21. And Senate Bill 21 amended Section 144 to create some safe harbors for companies involved in these type of transactions, and also amended Section 220. Do we want to go over some of those safe harbors, Sarah? You want to talk about maybe what each one of the kind of safe harbors were for Section 144 real quickly?
Sure. So as I said before, we had this MFW creep where now basically anything involving a controlling stockholder is subject to entire fairness. We also had what I didn't talk about, which is if you have transactions that uniquely benefit fiduciaries other than controlling stockholders, right? So directors and officers, those could also be subject to entire fairness. So 144 seeks to address that in several ways. So first, one of the safe harbors under 144 is Section 144A, and that involves transactions transactions involving directors or officers where there's no unique benefit to a controlling stockholder or control group. So situations involving director compensation, directors participating in a financing, something like that, where you don't have controllers, but you have directors or officers that are getting a benefit. Now, in that context, you can use either one of what we traditionally thought of as the two MFW protections. If a board forms a special committee of independent directors and that special committee in good faith approves the transaction and a majority of the independent directors on the special committee approve the transaction, that alone, standing alone now, is sufficient to insulate the transaction from fiduciary liability. Similarly, if you chose to have a stockholder vote on the transaction, so maybe you don't have enough directors to have a special committee or you don't think that you've got sufficiently independent people, but you just have a stockholder vote on the transaction, just having that stockholder vote now is also sufficient to insulate that director officer benefit transaction from fiduciary liability. Second, now in 144B, you have transactions that involve controlling stockholders or control groups, but are not what's considered going private or take private transactions. So some of those things I mentioned before, where there's some transaction involving a controlling stockholder, debt financing, buying a piece of property from the controlling stockholder, but that's not the controlling stockholder taking out all of the rest of the minority stockholders. That, similarly to the interested director transactions, now you can use one of the two historic MFW prongs. You can either have a special committee or you can have majority of unaffiliated stockholder vote, and that protects the transaction from fiduciary liability. Then you have 144C, which is what we think of the traditional going private transaction involving controlling stockholders. And that going private transaction, the legislature has still recognized that those are sort of the most fraught with risk and the fraught with overreaching potentially by controlling stockholders, such that the traditional dual protections of both the special committee and a majority of unaffiliated stockholder vote is required in that circumstance to provide a cleansing. There are some tweaks to what we would consider to be the traditional MFW process for that, which is you don't have this, quote, ab initio requirement. The special committee doesn't have to be in place from the minute the transaction is a glimmer in anyone's eye. You can also have a majority of independent directors on the special committee. Not every single one of them has to be independent. And the vote of the unaffiliated stockholders is now a votes cast standard as opposed to a majority of outstanding. So there's some tweaks to the traditional MFW, but going private transactions are still subject to that, what we would call like the dual prong of MFW. So those are sort of now three safe harbors where for anything other than a going private transaction, you don't have to jump through the full MFW hoops anymore. You can basically do one or the other.
And then I think we also have to talk about 144E. We when we were going through the background, we talked a lot about how the kind of the genesis of everything involved conflicted controller stockholder transactions. 144E puts a little definitional clarity on what is a controlling stockholder and how it's going to be applied by the court in 144 cases. Justin, you want to talk a little bit about 144E, kind of what defines the controlling stockholder now going forward?
So previously, courts determined who was a controlling stockholder on a case-by-case basis. We've seen instances where controlling stockholders who own less than 20 or 30% of the stock were deemed controlling stockholders. Made it very difficult to determine at the outset, absent court guidance, who would or would not be considered a controlling stockholder. 144E put in place a bright line definition, which now defines a controlling stockholder as a person together with affiliates and associates who owns or controls the majority in voting power of the outstanding stock of the corporation, who vote generally in the election of directors or in the election of directors who have a majority in voting power of the votes of all directors. Under this prong, you're a controller if you have 50% or more of the stock and you get to vote a majority of the board, or if you get to have less than 50% or any voting percentage that elects directors who control the board. Second prong is a controlling stockholder together with affiliates and associates who has a right by contract or otherwise to cause the election of directors who constitute either a majority of the members of the board or directors entitled to cast a majority in voting power of the votes of all directors. So this looks through pure voting power and says if you have a contractual right to control the board of a company, you're a controlling stockholder. The third and last prong, and again, these are exclusive, so if you tick any one of the prongs, you are a controlling stockholder under the new statute. The third prong is having the power functionally equivalent to that of a stockholder that owns or controls the majority of voting power of the outstanding stock by virtue of ownership or control of at least 33% in voting power, entitled to vote generally in election of directors, and you have power to exercise managerial authority over the business and affairs of the corporation. So this is akin to something like a CEO, large holder, or even just a non-executive controller who's meddling in the day-to-day affairs of the corporation.
Great. And I think we should also say that there are other amendments to 144 that were made as well. We're not going to have time to talk about every single amendment that went into 144, but I think these are the major or most important enactments that are amendments to that law for purposes of our discussion. Now, we talked about what it is. Let's talk about the good part here, which is even though these are relatively new changes just in March of this year, what do we expect to see from this? When we're counseling clients, when we're litigating cases, what do we expect to see and how do we expect these new changes to affect the way in which we practice and the way in which our clients do business? Sarah, you want to start us off with that a little bit?
On the deal advising end, on the front end, right? First of all, I can tell you, you are a controlling stockholder or you're not, right? There's now basically a quantitative test for it. Whereas before it was a qualitative test, it was sort of squishy of, well, you don't have enough stock, but maybe you've got enough influence. Now we can pretty clearly delineate whether or not you're a controlling stockholder, right? And then based on that, we can say, okay, are you a controlling stockholder? Is this a take private or is this one of these other types of transactions where someone's benefiting? And then we can structure it, right? We can say, okay, here's what your special committee needs to look like. Do you need a vote? Yes or no? It makes it much easier from a transactional planning perspective to tell people what they need to do. It also makes it, I would say, much more efficient for clients in terms of process and cost, and that a traditional MFW process to do it right is a lengthy and time-consuming process. Whereas now, if you can either just have a committee or just do a vote, it's not as costly because you're not having to have both elements, and it doesn't take as long because you're not having to necessarily have a committee followed by a vote. So it really streamlines transactions, particularly that are not what I would call company transformative transactions like a take private, right? If it's a relatively small scale transaction, but that has some ancillary benefit to a controller or a director or officer, you're not having to go through the time and expense of doing the full-blown MFW process. That's a big benefit to clients. And again, it makes it more predictable and that we can get a pretty good handle on what an outcome of a litigation would look like and hopefully get things dismissed more often at the pleading stage using section 144, as opposed to before, as Justin said, you're like batting 50% on an entire fairness cases are very onerous and expensive to take to trial. So I think now when you have interested transactions, we're going to see those get dismissed to the pleading stage more often, assuming people do it right under 144. But we can now tell you with much more predictability how to do it right.
Yeah, so it's a lot easier to engage in these type of transactions, right? And for clients to do it on a more streamlined and cost-effective basis. Is that fair?
Yes, but in a way, yes, a streamlined, cost-effective basis, but also in a way that the legislature has decided offers sufficient protections to minority stockholders.
Absolutely. And Justin, going forward, I mean, do you have more to add as to what maybe we'll see as benefits or what we expect to see from clients with the new 144 land that we're living in?
As you both alluded to, the potential benefits of complying with 144 are huge and transformational, really. So for public companies, directors who meet, especially public companies on the New York Stock Exchange or NASDAQ, they're independent directors who meet the listing standards for independence, have a presumption under the new statute that they're independent. So you're going to see, I think, increased focus by those companies on making sure they have great independent directors who are ready, willing, and able to step up and negotiate these types of transactions, because that's the easiest path to getting a fully compliant committee.
Let me stop you there just for a second. That actually benefits stockholders, right? Like these are good things. These are good things for the law, both for the companies and stockholders of companies as well, right? We want the best directors. We want directors to be empowered to do what they need to do. Fiduciary duties still exist, but now we just have a better framework to allow directors to go about doing the transactions they need to do and to have certainty as to what it is they're doing, right?
I agree. You're having independent directors who are well qualified, who the stockholders are voting for, to approve and assess these transactions, and it should decrease litigation costs and drag for all stakeholders. And you get to police who those independent directors are by voting them in or out, potentially. So, and in the private company context, there is no such presumption, and often it is difficult to find truly independent directors. So I think that you're going to see some larger cap private companies start to evolve their boardroom and start to engage more independent directors who are truly independent and aren't the representative of a fund who's invested or the founder. And they're going to want to have some folks on the board who can step into these roles. Because look, it's recent, right? But we're still counseling private companies, and you say, oh, 144 is great, let's talk about it. And then you go through and you count heads in the boardroom, and there's nobody available to meet the minimum of two members on the committee. And then it's like you're weeks away or months away from a transaction. And they say, well, we're not going to bring somebody brand new in. Like, A, where would we find them? And B, how do we get them up to speed in time? I think boardrooms are going to continue to evolve in response to this. And I think we'll maybe see some more independent directors on private company boards.
And then I think we should just touch on, we've raised the Section 220 books and records a couple of times already. We should just touch on exactly what the changes were, maybe a little bit of a background of kind of how we got to needing some changes, or how we got to having some changes to 220. And then now what the new 220 landscape looks like. Sarah, Justin, either one of you guys want to touch on what our new 220 world is going to be looking like post these amendments?
Sure. So as Justin said before, in prior to 220 litigation, we were starting to get into a world where it was almost mini plenary discovery at the pre-suit litigation stage, where if people alleged certain facts or that you were missing certain things, that they could start getting emails, they could start getting text messages. And 220 was really getting unwieldy. So now the statute has been amended to give a actually specific delineated list of what are considered books and records of the corporation for purposes of Section 220 demand, which is basically the charter, the bylaws, stockholder meeting minutes, things you've sent to stockholders, and most importantly, minutes of any meeting of the board of directors or committees thereof, or records of any action, so like unanimous written consent or resolutions, materials provided to the board and committee in connection with those actions, annual financial statements, agreements entered into under Section 122.18 of the DGCL, and D&O director and officer independence questionnaires. So it's really cabining it to sort of what we would consider to be formal board materials, D&O questionnaires, and then some constituent documents of the corporation. Really taking out that what we would consider to be non-traditional books and records of electronic discovery in the 220 demand. And the statute basically now says that assuming that the company actually has these books and records, the court can't order books and records inspection beyond that. If you've got this, if you have maintained your books and records, then that's it. That's the end of it. So now when you get a books and records demand, this is the list of what we have to produce. It's formal board materials plus this other handful of things. That's it. You're not getting emails. You're not getting text messages. It has sort of two effects, right? It incentivizes corporations to keep good books and records of their corporate action. And then it makes it much easier for companies to respond to Section 220 demands and much less burdensome.
Absolutely. And we should note, and Sarah, those are great points. And 220 litigation can be long and it can be expensive, notwithstanding that I believe the statute says it should be a summary proceeding. Some 220 books and records actions can go on for some time, and they can be very, very expensive over essentially company documents. And if your company is keeping your documents now, you're going to be able to kind of hedge that off a little bit and move forward with whatever you got going on. The other thing that I think is important to note, though, is this doesn't necessarily eliminate the possibility that if the company is not keeping its records, adequate record keeping practices, the emails and other type of what we'll call maybe second line documents that a company has are still going to be subject to having to be produced. So if you as a company, you cannot hide behind 220 if you don't adequately take minutes and keep your records sufficient as required. We're going to be right back into the same place where emails and other maybe officer level type documents can be ordered to be produced by the court. So we want to make sure that we note that while there are these changes to 220, it really gives a company an opportunity to do what it needs to do. But to the extent the company is not maintaining its proper books and records, we're right back into the situation in which emails, officer level communications, and other documents are now subject to 220, the same as they would have always been.
Definitely.
Yeah, and that's important to remember too. I mean, not that many corporations have that issue, but it still does apply. So
yeah, I find that's an issue. Look, with smaller private corporations or with corporations who aren't engaging in a transformative transaction where they're like, oh, we're going to sell this asset or we're going to do like a small financing or something like that. We'll just do it over email or we'll let our CEO negotiate it and the board doesn't get involved. Well, when there's some specter of misconduct in connection with that transaction and it has either not gotten to the board level or the board didn't act on it, you can be back in the world where you're getting electronic records.
that's right. All right. So we've talked a little bit about 144. We've talked about the amendments to 144, the new safe harbors. We've talked about 220. I feel like we have to at least bring up the fact that as most new legislation or important new legislation is presented, it's challenged. And here we've got in Delaware a constitutional challenge to certain provisions of the new section 144. I'm not going to describe it as sweeping broad challenges, but rather maybe finite challenges to some specific portions of 144. And the case is Rutledge versus Clearway Energy Group. And the oral argument before the Supreme Court is going to be taking place here in a couple of days. Sarah, Justin, when do you want to just touch on what kind of is being challenged in that case? And maybe it's the impact that some of those challenges could potentially have on some of these new enactments for 144?
Sure. So there's two provisions of 144. As you said, it's not like a sweeping challenge to all of the provisions of the statute and do you need a special committee or not. It's really two discrete areas. First, Section 144 says if you satisfy the safe harbors of Section 144, the transaction cannot be subject to either equitable relief or damages against directors, officers, or controlling stockholders. And the group of people that are challenging the constitutionality of 144 says that provision violates the Delaware Constitution by purporting to divest the Court of Chancery with its constitutionally guaranteed equitable jurisdiction by prohibiting the Court of Chancery from issuing equitable relief in these circumstances. Second of all, there is a retroactive provision of SB 21 where SB 21 said it was effective for certain transactions that predated the enactment of SB 21. Basically, like the minute SB 21 was proposed, but before it was actually adopted, there's a month or so window of time. And during that period of time, the statute was retroactive to the date that the statute was actually proposed, not adopted. So plaintiffs are alleging that violates the Delaware Constitution by purporting to eliminate causes of action that had already accrued or vested. So there's going to be a narrow subset of transactions that potentially fall within that window.
Yeah, and these are very narrow challenges, and we should also make clear that this litigation is ongoing. We haven't heard from the court regarding it yet, so we don't know what these outcomes are going to be necessarily on this or where this will come out. But I think it's fair to say that these challenges are not going to necessarily blow up or change 144 dramatically, such that everything we've talked about here today could be not applicable in a week or 2 weeks' time. I think this is still good information and good for us to learn, discuss, and talk about here. And we'll keep updates on the constitutional challenges to 144, but we're still in the same land. Is that fair to say for everybody?
Absolutely. Worst case scenario, there's maybe a very narrow time period or a narrow form of relief that can't be offered anymore. But I don't think it's going to, even if the court finds that these constitutional challenges are warranted, it's not going to eviscerate the whole statute. So we're certainly keeping an eye out for it, but I don't think it is changing how we advise clients in the interim.
Great.
Agreed. And I'd expect a response legislatively or otherwise if certain features of it are struck down, given the speed and sweeping changes that were enacted and the motivation to do the same. So,
all right. Well, look, I want to thank everybody for listening, tuning into this podcast, for learning a little bit about Section 144, the amendments to 144, and the amendments to Section 220. We had a lot of fun talking about it. I want to thank Sarah and Justin for coming on, our Delaware experts, to talk about these issues. If anybody out there listening has any further questions about Section 144 or 220 or want to discuss these issues, the GT Delaware office is ready to talk about these issues, to provide guidance or any support, including background information on this as needed. Reach out to myself, Sarah, Justin, anybody else here, and we're happy to try to address any questions or concerns or topics that may be applicable or that you may want to discuss. And with that said, everybody, we thank you so much, appreciate it, and look forward to seeing you next time.
Great. Thanks, Sam.
Thanks.